Thank you, dear colleague. I wish you to greet you all. I'm very happy to be here today with you, and I would like to express my gratitude to the organizers of this really, really great event. And I will go further with our presentation by saying some few words about education and healthcare system in Croatia as a part of child protection system. It will be just briefly, really briefly overview of these systems. When we talk about the education, it is important to say that in Croatia, preschool programs are organized and co-financed by local or regional self-government units and the state budget, but also parents participate in financing of some costs. Compulsory education in Croatia is, according to the constitution, free of charge, but the same does not apply to secondary education, although the most students attend secondary schools that are predominantly organized within the network of public schools whose programs are free of charge for enrolled students. Textbooks for all primary school students in Croatia are free, provided by the state budget. Extended stay services in primary schools, which are organized predominantly for children under third grade, are financed partially by local and regional self-government unit and partially by the parents. The government of the Republic of Croatia has decided in 2023 to finance the program of one free meal for all children in primary schools using the state budget. Considering the healthcare, the most important is to say that all children in Croatia under the age of 18 have free access to health services through compulsory health insurance, and also children do not pay participation costs for hospital stays, specialist examination and medications. When we talk about the children with disabilities as a special vulnerable category of children, according to the Croatian constitution, those children are entitled to special care, education and welfare. Increased material needs of those children due to their disability are considered when determining the amount of child maintenance in court proceedings. The Social Welfare Act also provides specific allowances for this category of children, such as personal disability allowances, allowance for help and care, and allowance for the status of the parent caregiver. There are also social services which are of special importance for children with disabilities, and these services include psychosocial support, early development support, and assistance with inclusion in education and regular education programs. Preschool Education Act and Primary and Secondary School Education Act regulate the status and certain benefits of children with disabilities within the national education system. For example, provision of a teaching assistant and professional communication mediator. Several legal sources that are relevant for the healthcare also regulate the status and certain benefits of children with disabilities and their parents as primary caregivers within the national healthcare systems. Considering authority measures, my colleague spoke a little bit about these authority measures, and I will just say a few more words about these measures. It is important to say that in each particular case, the measure imposed must correspond with a principle of proportionality, namely in each case, imposed measure must be aligned with the degree of endangerment and violation of the child's rights and welfare. Competent authorities for imposing these measures in Croatian legal system is Croatian Institute for Social Welfare and the court. Court mainly imposes repressive measures, and the Institute for Social Work imposes preventive measures. There are a plethora of measures in our system of child protection, from warning, which is issued to parents regarding errors and omissions related to the care and raising of the child, up to measures that are repressive nature and which entails separation of the child from the family. Deprivation of the right of parental care is the strictest measure in our legal system. When one of the repressive measures is imposed to parents, that measure should not last longer than it is necessary, and during such measure, parents should be provided with assistance and support to improve their parenting skills, because one of the aims of such measures is creating conditions for family reunification if it's possible, unless it would be contrary to the child's best interest, or preparing another permanent form of care for the child. It is also important to emphasize that in all procedure for the impositions of these authority measures, competent authorities must act promptly while simultaneously protecting the child's welfare. When a repressive measure is imposed, but also in other cases when child is separated from his or her family environment, alternative care of such child shall be ensured. I would just say at this place that there are some challenges when it comes to placement of the child outside the family in Croatia. We have problems with insufficient capacity in institutions and foster families, uneven territorial representation of foster families, lack of foster families in urban areas, as well as lack of specialized foster parents. And problems exist also with foster parent structure and needs. One of family law institute that is intended to protection and care of children without adequate parental care is the Institute of Guardianship, which substitutes parental care for parents for children whose parents have died, disappeared, are unknown, or they're otherwise legally or factually unable to take care of the child. The Croatian Institute for Social Work decides on placement of the child under guardianship and appoints an individual guardian. Individual guardian is a child's legal representative who is responsible for protection of the child's personal and proprietary rights, and by decision making, it is important to say that the guardian shall consider the opinion of the minor ward in accordance with his or her age and maturity. When Institute for Social Work decides on placement under guardianship and they decide about the person of guardian, it is required to respect the parents' previously expressed wishes in advance the directive regarding the selection of a guardian, if that person meets all legal requirements for be a guardian. And finally, just a few words about the special form of family law providing for and taking care of child without adequate parental care, namely the adoption. Final decree on adoption establishes unbreakable kinship relationship between the adopter and his or her relatives on the one side, and the adoptee and his or her descendants on the other, as well as all the rights and responsibilities stemming from such relationship. Since 2003, in Croatia we have only one form of adoption, and that is the full adoption. The preliminary procedure of evaluation of suitability and eligibility for adoption, as well as the procedure for establishing adoption, are carried out by the Croatian Institute for Social Work as the competent authority. Adoption can be established only if it is in the best interest of the child. So the best interest of the child in the context of adoption is the decisive factor, a standard that must take precedence. And in the adoption procedure, the characteristics of the prospective adopter are evaluated in regard with the welfare of the child. When it comes to legal position of the child in the adoption procedure, it is important to say that if child is 12 or older, then his or her consent is required to establish the adoption, but also for changing personal name or nationality. If child is younger, then the consent of that child is not required, but the child has right to express opinion about the adoption, and his or her opinion will be taken into account in accordance with his or her age and maturity. And at the end, just a few concluding remarks. We can say that Croatian legal framework of the child protection system sets high standards by fully incorporating global and regional international guiding principles. Nevertheless, challenges of implementation in practice persist. It is important to emphasize that constitutional duty of all is to protect children, and although primary responsibility for care and protection of children lies on their parents, a subsidiary role of the state authorities is of extremely importance. since the role of state is to provide assistance and intervene in family life of parents and children in accordance with the principle of necessity and proportionality. Furthermore, we must be aware that every individual who has knowledge of a violation of endangerment of a child's rights has a legal duty, according to the Family Act, to report it to Croatian Institute for Social Work. Promptly reactions of competent authorities, professional assessment, and intersectoral cooperation in order to provide timely and appropriate child protection are of the utmost importance. Therefore, further and continuous investment in empowering of child protection system is a conditio sine qua non for the future of our society. Thank you very much for your attention.